right. Hey, Eli Skinner here. Simplify at Fathom Realty. At least as of the time I'm recording this, which is July 13th of 2022. There's going to be always changes to documents, but as you can see, I'm inside of our team world of zip forms. I've clicked templates right here. I've clicked purchase residential, and here are the documents. And so we've covered a lot of ground, and now we're going to jump through some actual other documents. We went through the purchase agreement, which took a long time, but now we're going to hit these other documents and how to fill them out or what they're for. And I'm just going to kind of work my way through these that are already in the template first, so you kind of get the most important ones out of the way right now, and then we're going to also be working through as many as we possibly can in the future, but each one will be its own separate video as long as I can remember. So an office policy, I'm just going to click this. Every company creates their own. I believe the Indiana Association of Realtors has kind of a version you can use, and I actually used it when I had my own company for a bit, but Fathom's got their own. And I like to, in the words of the guy who taught me a lot of things, he used the example of leveling the playing field. We understand as agents what agency is. It's the agency relationship. But the people we're serving do not. And so it's important that we disclose things about this agency relationship to make sure we're on the same page and our relationship is set up well. I'm not going to read this entire thing. I want you to absolutely read the entire thing. But you'll see here that Indiana law provides that a licensee has an agency relationship with and is representing the individual with whom the licensee is working unless there's a written agreement to the contrary or the licensee is merely assisting the individual as a customer without compensation. So consumer agency is something that can be implied or explicit. So implicit or explicit. Explicit is this: we've signed some sort of document, like a buyer's agency agreement, for instance, or a listing contract that is clear as day that says we're working together and I am your agent. Or it can be implicit that says, there's no document in place. There's nothing that says that we are working together, but there's also nothing that says we're not working together. And if my rule of thumb is that if the client feels, if the person, the human, feels like I'm their agent, guess what? I'm likely in what's called implied agency. You learned about this in your real estate courses. So according to, I'm not a lawyer, so you can go ask one of those guys, but the way I read it, the way I feel about it, the way I think just as a human, if they think we're in an agency relationship, if they think I'm their real estate agent, if they think I'm looking out for their best interest, guess what? I probably am supposed to be by implied agency standards, and I think you would lose in court if they said, well, I thought Eli was my agent. I didn't know Eli wasn't, working for my best interest. Boy, I think I'm going to end up in trouble. So if I am providing advice, help with documents, blah, 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 then and I don't really want to be in an agent relationship with them because I'm on the other side of the deal or whatever, then I better have a written agreement to the contrary, or I better have clearly expressed in some other ways that I'm just helping you as a customer versus a client. A customer, somebody that's maybe coming to buy my listing and you don't have representation, I might be just helping transmit documents for you and I'm not getting paid by you, okay? So I like number one, and there's a really good form called the FSBO, or for sale by owner compensation agreement, that does this exactly. And I have copied that language multiple times. If I was helping somebody as a customer, I wrote it in the purchase agreement, the same language that was in there. So I had written agreement to the contrary. I was not working for them as an agent. So this is what this office policy says. It tells your clients, hey, we're working together. I'm your agent. And then it starts to talk about what our responsibility is. The licensee, I might end up reading the whole thing. The licensee, meaning me, the realtor at Fathom Realty, represents the interests of the buyer. This is a buyer one you'll see here. There's a seller one as well. When showing a property not listed with the licensee, nor with the principal broker of Fathom Realty. Okay, so if I don't have the listing and Brent doesn't have the listing, our managing broker, such licensee owes the duties of, and here's our responsibilities: trust, loyalty, confidentiality, accounting, and disclosure to the buyer. However, licensee must deal honestly with a seller, even though we're not representing the seller. And all representations made by licensee are made as the agent of the buyer. So I have a big responsibility here. I am got to be trustworthy. So I've got to be honest at all times. I've got to be loyal. I've got to maintain confidentiality. I can't tell things I'm not supposed to tell to the other side. That's going to hurt my client, and you'll be surprised what can hurt the other client. Accounting, I've got to keep track of the money and paperwork. I've got to disclose things to the buyer that they need to be doing. It's my responsibility to help them through what inspections to do. But I do still have to deal honestly with the seller. I can't lie and play tricks on them. And I am operating on behalf of the buyer. Limited agency disclosure authorization. We've talked about this a little bit at the bottom of the purchase agreement, but there are so many places where they give us permission to be a limited agent, which is where I represent both sides of the transaction. It's fine. It's tough. You feel a little dirty the whole time because you're worried, because it's really hard to, you have two clients now, and one's a seller, one's a buyer, and the buyer does inspections and wants you to punch the seller in the face, and the seller wants you to turn around and punch the buyer in the face, and you're like, gosh, I like both of you. I'm trying to help both of you. So I try to stay away from it, but if it arises, here's one of the places we deal with it. The licensee or the principal broker may personally represent a seller as a seller's agent in the case of a property listed with Fathom Realty. So if Eli's got a listing or Brent has a listing, then we're telling them that may happen, and they're going to be okay with it. Okay, if that occurs, then the licensee has agency duties to both buyer and seller, which may be different or even adverse. If limited agency arises, licensee shall not disclose the following without the informed consent in writing of both people. And then here's the list. Material or confidential information, except for adverse facts about the house that are required to be disclosed. Because, there are things that even if the seller won't disclose, us as agents have to disclose it by law if we know about it. But I love this. This helps you think through inspections. Material facts or risks actually known by the licensee, so not implied knowledge, it's got to be explicit actual knowledge concerning the physical condition of the property and facts required by statute, rule, or regulation to be disclosed that would not be discovered by a reasonable and timely inspection of the property by the parties. Okay? That means the way I read that is if I can't do a cursory walkthrough during a showing and find it, then it needs to be disclosed. I can't disclose if I'm in limited agency representing both sides. I can't disclose that a buyer will pay more than the offered purchase price for the party. And this is regardless of if I'm representing both sides. I can't ever tell the other agent, that is the listing agent, hey, my buyer offered you $250 and you were listed at $300. I'm telling you, just get me a counter. No, what did you just imply to that agent? That we would pay more than the offered purchase price of $250. You can't say stuff like that, okay? The seller would accept less than the contract than the list price. So this if you are a limited agent, or if you're on the other side and you end up being on the seller side, you can't, say, well, just get me an offer to a buyer's agent because you know that the seller will come down on price. You can't do that unless you have explicit knowledge or explicit written information from the seller to do that. You can't say, you can't do anything to harm the seller. Other terms that would create a contractual advantage for one party over another party. I mean, you just can't, that could go any number of ways. And then what motivates a party to buy or sell the property? Hey, the seller's moving to Florida next week on a job change. They got to get out of here. Well, you just gave an advantage to the buyer, who now knows the high motivation level of the seller and might now not pay quite as much for the property. So you can see this document is required by law because now your client can check in on how well you're doing your job as an agent. Okay? In a limited agency situation, the parties agree that there will be no imputation of knowledge or information between any party and the limited agent or among licensees. Okay? We're not going to move knowledge around willy-nilly. No, I'm not going to go into everything means, but this is why we read this. Okay, I'm doing my best to give you an overview of this document. Required duties disclosure. There is a minimum level of standard. What is it called? It's like minimal level of service or something. I don't remember, but basically that. Indiana law, that one right there, provides that a licensee must perform at least the following duties for the buyer. So if you're going to represent a buyer under any circumstance in Indiana, you have to at least do these things. You can charge less money and do only these things, or you can charge a ton of money and do a lot more things, but these are the minimum standards of service. Be available to receive and timely present offers and counteroffers. Okay? Assist in negotiation. So, for instance, on that one, here's a great example. If you're going to be one of the agents that somehow has figured out how and wants to take nights and weekends off, like a kind of a normal 9 to 5 Monday through Friday job, I'd recommend you get it in writing that your client's okay with that. So, because if they get a counteroffer on a Friday at 5:01 p.m. and you've already clocked out for the whole weekend, well, that counteroffer may not get to your client until Monday at 9 a.m. Well, it's long expired at that point, and it's your problem, your fault. And if you don't have something in writing that said that they knew you were off starting 5 on Fridays and all the way till Monday at 9 a.m., you're going to be in trouble because that's not considered available to receive and timely present offers and counteroffers, in my opinion. Okay. This is one of the biggest deals of their life, and I'm pretty confident most clients expect their agent to be available nights and weekends during these crunch time moments in these offers or inspections, okay? So that minimum standard 1, be available to receive and timely present offers and counteroffers. Assist in negotiating, completing the real estate forms, communicating and timely presenting offers, counteroffers, notice, various addenda relating to the offers and counteroffers until A, a purchase agreement is signed, and B, all contingencies are satisfied if they're waived. So we can't merely get them to just the purchase agreement being signed. We have to get rid of all the contingencies, inspections, appraisals, HOAs, all that stuff has to be done, okay? 3, we have to timely respond to questions relating to offers, counteroffers, notices, various addenda, and contingencies pertaining to this subject property. We got to answer the questions. So we got to be available to receive and present offers and counteroffers. We have to assist in negotiating, help them complete forms, communicate, timely present everything related to the deal. And we have to stay involved in that manner of presenting things, communicating, explaining, etc., until the purchase agreement is signed and all contingencies are complete. Then, and just think, the last contingency I can think about completing is getting clear to close. So once clear to close is done, I guess you may be off the hook, but I'm not even sure at that point you're technically off the hook. I mean, I've never felt like I was off the hook once they got clear to close from their lender. It ain't over till it's over, right? Which is closing. And then the third one is timely respond to all their questions. You got to answer questions, okay? Now, one thing that I'm not sure is in here, it may get here, but I'm going to throw it in right now in case it's not, is because that's a section of law here, and then there's a different section of law that we must attend closing. So I'm going to add a number 4 down here in my mind that says we have to attend closing. If it's out of state, if it's hours away, if it's remote, whatever, then you don't have to, but you have to attend closing if it seems feasible at all. Now, again, this is why this document by law is to protect the consumer. If a licensee fails to perform the above duties and another licensee performs those duties on behalf of or at the request of the buyer, then the performance of those duties does not constitute an agency relationship. So if you failed to explain the purchase agreement to your client and I explain a purchase agreement to your client, that does not constitute me now being their agent. Okay? That's important. Furthermore, a licensee may lawfully perform duties in addition to those minimums up there on behalf of or at the request of the buyer. So you can't steal somebody's client by just explaining a document to them, okay? And then vice versa, if I have another agent explain the document, it's not me losing my client as an agent. A licensee's duties in a real estate transaction set forth in this office policy do not relieve the buyer, this protects us, from the responsibility to protect his or her own interests. The buyer should carefully read all documents to assure they adequately reflect the buyer's understanding of the transaction. And if legal or tax or other expert advice is desired, buyers should consult a qualified professional. Okay? Easy enough. That saves our bacon. Code of ethics and standards of practice, blah, blah, blah. This is code of ethics stuff for being a realtor. This is different than legal, but it is we are part of MIBOR, which means you are a realtor, which means you have to adhere to the code of ethics and standards of practice, which if you don't know, you can go find out very easily. And this will help you with buyer's agent compensation and legal side of that. But I do want to just tell you that this is different than legal. So you got legal stuff and you've got the club we're in, which is called being a realtor in MIBOR, and you need to follow both. If there's ever a situation that arises that you feel that following MIBOR's rules would then break the legal rules, you need to contact me. It absolutely happens. And I'm a big fan of you just have to do what's legally right, not necessarily a MIBOR rule if they do conflict. And they do conflict occasionally in weird situations. They don't conflict on the norm or they wouldn't have those rules. They're not dumb. But there are times when they do conflict. So just be ready for that. Just some bonus information there. Generally speaking, though, if you're following the MIBOR rules and realtor ethics, you are going to be operating at a higher ethical standard and legal standard. So they're a great thing. The Code of Ethics and Standard of Practice of the NAR provides that realtors must advise clients of the company cooperative compensation policies and the possibility that sellers or sellers' representatives may not treat the existence, terms, or conditions of offers as confidential unless confidentiality is required by law, regulation, or other confidentiality agreements between the parties. What that says is there might be behind the scenes compensation things going on that are not being disclosed because they're not being told they have to be disclosed. This is the BAC may not be being disclosed. Buyer's agent's compensation may not be being disclosed to all the parties. The seller knows what they're offering you as the buyer's agent. The listing agent knows what they're offering you as a buyer's agent. You might know what they're offering you as a buyer's agent, but your buyer may not know until closing day what you're getting paid. And this is just letting them know that there's a possibility that there's things that that you as a buyer are not going to know. Um, the terms and conditions of offers and the compensation and other things until it's required to be disclosed. It may not be being disclosed. Further, if the seller has approved disclosure of the existence of offers on the property, realtors shall also disclose whether offers were obtained by the listing licensee, other licensee in the firm, or the cooperating broker. So what that's saying is that when you do a listing contract, there's a box that's going to say the listing agent shall or shall not disclose the existence of other offers. If it is marked that the listing agent may disclose the existence of other offers, the listing agent also must disclose if it was the listing agent wrote the offer for another buyer, somebody in their office wrote for another buyer, or if it was a licensee in a listing firm or by a cooperating broker from another company. So, if a listing agent, wrote a limited agency offer, so they listed the house and they brought a buyer and they're told they are allowed to disclose the existence of offers, they then have to tell us if it was the listing agent themselves that wrote the offer. They can't hide that and use that as ammo. Okay? It is a lot to this, but this will start to make more sense. But if you as a listing agent are allowed to disclose the existence of other offers, then you have to tell people, hey, there is another offer on the table. It is my offer as a limited agent. Or, hey, it's an agent in my office wrote the offer. Another, carpenter agent on a carpenter listing. You have to disclose that. If they can't disclose the existence of other offers because that's the way the listing contract is written, then you'll never know. And that's fine. I do that a lot. I actually don't do the disclosure of other offers because I don't want to have to mess with it. I just tell their agents, go fly kite. Or, hey, the market. You got to assume there's offers, right? And then there may or may not be. By signing below, buyer acknowledges that limited agency authorization has been read and understood. Buyer understands the buyer does not have to consent to licensee acting as limited agent. They're giving their consent by signing this, but gives informed consent voluntarily to limited agency and waives any claims, damages, losses, expenses, including attorney fees, costs against licensee arising from their role as a limited agent. So basically, buyer knows that I might list them. I might take them to my listing. I don't have to disclose it. Don't have to ask for permission. Blah blah blah. Guess what? We're still going to disclose it when it comes up. But there's 2 or 3 places that you're going to get this already dealt with. Affiliated business arrangement disclosure. Affiliated business is when a mother company or a parent company, my fault, which I guess a mother is a parent. A parent company owns multiple different companies that may be getting paid in the transaction. So Fathom Holdings has a business relationship with Verus Title, specifically that Fathom and its affiliates entities directly or indirectly have beneficial interest in Verus Title. Because of this relationship, this referral may provide Fathom a financial or other benefit. So we're letting them know that we may or may not end up using Verus Title, but in the event we do use Verus Title, boom, we've done the affiliated business arrangement disclosure already. It's not a separate form. Set forth in the estimated charge or range of charges. You're not required to use Verus Title as a condition, and blah blah blah. Okay, so then it gives these are ranges. Look, 0 to 3,000, 0 to 3,000, 0 to 500. Buyer settlement fee. That is not our settlement fee, but let's just leave it for that for now. It's like, I think it's 400. Actually, it's, probably 200, but some places it may be that. Title search and exam, blah, blah, blah. Acknowledgement, then they're going to, this is the buyer's only signature. Notice no signatures for an agent. I have read a disclosure and understand that Fathom is referring us to purchase the above desired title services, and Fathom may receive financial or other benefit. So, blah, 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 all this to say, you can see why the state would require us to give this to our client. It tells them so much about the rules, the laws, what could or could not happen, limited agency, how Verus and Fathom are tied together, what my role is. Every client when you become their agent, which can vary when that happens, but we primarily send this with every single offer we make. Okay? Every single offer we make, we send this. High diligence would say that you take this to your buyer's appointment and have them sign it right there. Okay? Because that's the moment you're becoming their agent and you need to disclose all these things. But at worst, send it with your offers. All right? If you got any questions, you can always put them in the comments or shoot me an email.